counsel, please.
Darren Levitt for the defendant.
Petty Shavantes on behalf of the state.
All right, and so the case is set for oral argument today on a motion to dismiss that asserts collateral estoppel, res judicata, and double jeopardy defenses. I've reviewed carefully the briefing with respect to that motion, so we're ready to proceed with argument.
I believe so, Your Honor. My client is online.
Okay, yeah, the record ought to reflect Ms. Barlow is participating remotely. Can you see and hear everything all right, Ms. Barlow?
I can, yes.
Okay, you can go ahead and mute your audio then. I wanted to make sure you could hear us. And so why don't you proceed with your arguments, your motion, you can go first.
Thank you, Your Honor. Good morning. We're here on the defendant's motion to dismiss under Rule 25B2 of the Utah Rules of Criminal Procedure, as well as on constitutional double jeopardy and preclusion and res judicata grounds. This is a prosecution for aggravated child abuse, and it is based on the exact same factual allegations, alleged intentional introduction of infection into Ms. Barlow's child, JB's bloodstream. Those factual allegations were fully litigated in a three-day, trial before and rejected roundly and expressly and explicitly by First Judicial District Court, Juvenile Court Judge Brian Galloway. After hearing from 9 medical experts and both parents over the course of 3 days, Judge Galloway explicitly found that the state failed to prove abuse, even by the lower civil standard of clear and convincing evidence. JB was found dependent upon his parents, as a medically complex child, but expressly found that he was did not suffer non-accidental harm or abuse and was returned to his parental custody. That judgment became final when the state did not appeal it. There are no new facts, no new legal theories, no changed circumstances in the year plus since that April 2024 decision by Judge Galloway. The state now seeks to retry the exact same issue and facts in criminal court under a higher burden. The law does not permit that. Rule 25B2 allows the court to dismiss when the allegations fail to state a public offense, And here, where the allegations, even if true, do not constitute a public offense, where Judge Galloway was unequivocal and stated in his finding there was no clear and convincing evidence of abuse. The medical evidence did not support a theory of medical child abuse, the exact same theory that the state brings before Your Honor in this case. If these facts could not meet a civil burden, Your Honor, they cannot possibly satisfy the criminal standard of proof beyond a reasonable doubt, and the state has failed to present a public offense to this court, and it should be dismissed under this 25B2. In terms of issue preclusion and collateral estoppel, this doctrine is recognized in State v. Somerville, 2013 Utah App 40, and Griffith v. Strong, both of which were cited in my brief. And relitigation is barred when we have the same issue that was previously litigated by the same parties. It was actually and necessarily decided with a final judgment on the merits. All of those elements are satisfied here. The state, despite what it argues, was the party in both proceedings, as proceeding and obviously as the plaintiff in this. Barlow intentionally harmed her child by medical child abuse, again, was squarely litigated and resolved against the state and in favor of Ms. Barlow and a lower civil standard. The juvenile court's findings were final and unappealed. Under those 4 requirements, the issue preclusion prongs have been met here.
Now, you cited cases from other jurisdictions that involved exactly this kind of circumstance, and you acknowledge that there were some jurisdictions where the issue went the other way, that involved a dependency hearing or some sort of abuse. attempt to do not either directly with
I was not able to.
Mavis, are you using the internet up there? Okay, thank you.
The defendant Crosby was the exact same facts present. Well, not the exact, but
I didn't.
Reasoning in that case, where the court said that the state should not be given a second chance to prove alleged wrongful conduct and cause the defendant to run the gauntlet a second time. And that's what essentially the state is requiring of Ms. Barlow with these proceedings. And in that case, the court found that the state had a full and fair opportunity to litigate, that it lost, and that it was now seeking a second attempt under a different label. And our position is that this violates Ms. Barlow's constitutional protections. And it compromises the finality of judgments. In the cases that I reviewed that went the other way, Your Honor, there was one from Michigan, People v. Moreno, and there was one from Washington v. Cleveland. In my review of both of those cases, the one they rested really on another prong of issue preclusion that we don't have in our case law, and that being that it doesn't run afoul of any public policy considerations. And that was the basis, I believe, in both cases. There was also an issue in the Michigan case that the court felt that the underlying proceedings there was basically a general verdict form. And so the court was unable to determine the basis upon which the previous litigation had been decided. By contrast, that is not this case. We have a very extensive findings and conclusions of law from the juvenile court. So I think it's easily distinguishable on those grounds. And the Crosby v. State of Arizona is very well reasoned and thought out. And the court in that case rejected the state's arguments that it wouldn't be fair to the prosecution or to the state to force them to be bound by these other non-criminal proceedings. And the court rightly recognized that it has a duty to also be fair to the defendants. And that was when it stated that it would be wrong to require a defendant to run the gauntlet a second time. As far as the res judicata issue, Your Honor, we also assert that bars repeated litigation of the same operative facts between
So res judicata is, as contrasted to collateral estoppel, is claims that were not brought but could have been brought. And a criminal child abuse offense could not have been pursued in the juvenile court up in Cache County, could it? So no one had the ability to pursue a child abuse offense up there.
No, not a specific offense, but the issue of child abuse was.
But that makes me think it's a collateral estoppel argument only. It's not a res judicata argument.
Understood, Your Honor, and just we included that just for purposes of total thoroughness.
Understood.
Just in summary, Your Honor, I think that the cases going the other way have been decided on other grounds. The Utah proceeding was full. It was a formal 3-day proceeding. It was adversarial. The DCFS was represented by the state of Utah and the state's attorney general's office. There was extensive testimony from many medical experts, and the state had every opportunity to present its case, the same case that it would present in this court, and it lost under a clear and convincing standard. In conclusion, Your Honor, this prosecution presents no new evidence involving the danger or harm to the minor child that have already been presented and roundly expressly rejected. This is precisely what issue preclusion and constitutional double jeopardy is aimed to prohibit. And to allow this case to proceed would undermine the finality of that previous judicial decision and the constitutional protections that is guaranteed to every citizen, including Ms. Barlow. Thank you.
Thanks very much. Let's hear from the state, Mr.
Thank you, Your
Smith.
Honor. Your Honor, excuse me. The state is asking for this court to deny the motion to dismiss on two of the following reasons. First, the information does comply or it does not fall within Rule 25B2. And second, this case is not precluded either by issue preclusion, claim preclusion, or double jeopardy. To begin with the simpler issue, this court should deny the motion to dismiss because the information filed is a public offense. Rule 25B2 of the Rules of Criminal Procedure allows for a dismissal if the allegation of the information does not constitute the offense intended to be charged in the pleading. Here, the state is alleging that the defendant intentionally harmed her child, and the conduct meets the elements of aggravated child abuse. As such, the state has filed the information in which the conduct constitutes a public offense. It is this conduct, Your Honor, that is not precluded by claim preclusion or issue preclusion. Beginning with issue preclusion, there's a four-prong test that was used in Oman versus Davis School District to determine whether issue preclusion bars litigation in the case. The four prongs are that the party against whom issue preclusion is asserted must have been a party to or in privy with a party to the prior adjudication. The issue decided in the prior adjudication must be identical to the one presented in the instant action. The issue in the first action must have been completely, fully, and fairly litigated, and the first suit must have resulted in a final judgment on the merits. Here, only the latter two prongs are met by the defense. The first two are not. The parties are not the same and are not in privy to each other. In the present case, it is the criminal arm of the state that is pursuing criminal charges against the defendant. Whereas in the DCFS petition, the Division of Child and Family Services would bring in a petition in the interest of the child. Here, the state of Utah has no client and is not bringing this case in the interest of anyone. These are different agencies with different powers, achieving different goals. The most important distinction is that DCFS cannot bring criminal charges against anyone. Whereas the present party, the state of Utah, can only bring criminal actions against individuals. And that brings me to the second prong of issue preclusion. The issues decided are not identical to the ones from the DCFS as it is in the present case. The DCFS hearing, the issue there was whether the court would grant DCFS custody of the child based on non-accidental abuse and neglect. In the state's motion, the state mistakenly only focused on the neglect part of the petition, but the DCFS also brought child abuse as part of the issue. This is important because abuse within the DCFS hearing is defined, among other things, as non-accidental. It is not defined as intentional. Non-accidental simply means that the result was not an accident. This is different than the definition of intentional. Utah Code 76.3-102 defines intentional as intentionality with the intent or willfully with respect to the nature of his conduct or to results of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. This distinction is important. Non-accidental requires simply that the result not be an accident, whereas intentional requires that the result be the desired outcome. This distinction separates the DCFS hearing from the present matter. DCFS did not have to prove the result was the required outcome. The state of Utah, in the present case, does. This matter is also not precluded by a claim preclusion.
It was the same. So I understand your argument with respect to the standard was this activity non-accidental in connection with the DCFS
Correct.
action. Was the activity intentional is the issue in the criminal action, but the activity is the same, right? Which is the contamination of the PIC line, whether it's some sort of an environmental factor or whether it was conduct by Ms. Barlow.
That's correct, Your Honor. The underlying conduct is the same. It's the issues which each different agency had to prove that are different. As stated in State versus Somerville, claim preclusion corresponds to a cause of action and bars parties from prosecuting a subsequent action, a claim that has already been fully litigated. This is similar or identical to double jeopardy as defined in Utah Code 76.1-1 21-403 subsection 1. The statute also codifies a two-pronged test for double jeopardy. First, in subsection A, the subsequent prosecution is for an offense that was or should have been tried under section 76-1-402 subsection 2 in the former prosecution, and the former prosecution resulted in either an acquittal, conviction, was improperly terminated, or terminated by a final order or judgment for the defendant that has not been reversed, set aside, or vacated, and that necessarily required a determination inconsistent with the fact that must have been established to secure a conviction in the subsequent prosecution. To begin the analysis, the DCFS case must be a subsequent prosecution that was or should have been tried under 76-1-402 subsection 2. That statute reads that whenever a conduct may establish separate offenses under a single criminal episode, unless the court otherwise orders to promote justice, a defendant shall not be subject to separate trials for multiple offenses when the offenses are within the jurisdiction of a single court, and B, the offenses are known to the prosecuting attorney at the time the defendant is arraigned on the first information or indictment. The DCFS hearing does not meet the elements of the statute. The allegations in DCFS were not offenses that were within the jurisdiction of this single court. The juvenile court is a civil court and not a criminal court. Even if the court accepts that there was jurisdiction, subsection B requires the offense be known to the prosecuting attorney at the time and the defendant be arraigned. Since there was no prosecuting attorney and the defendant was not arraigned until she was criminally charged, the defendant cannot meet the first prong of the double jeopardy statute. As such, the analysis stops there with the first prong, and this court can conclude that double jeopardy does not. Justice as it does with civil liabilities. The holding there laid the state versus preclusion attaches. Now, the defense also cites the Arizona case or court case with similar issues. However, the state believes that a similar outcome here will have detrimental consequences for both DCFS and the state in its criminal prosecution. For example,
well, and there are cases that go the other way, but you would acknowledge that your argument has to be that I shouldn't follow that case and should instead follow the cases that go in the other direction.
That's correct, Your Honor.
But that case is right on point, isn't it?
The case is right on point, but this court should follow the reasoning for the state in the case in Michigan. Simply put, because DCFS, at least here in Utah, of Utah that essentially creates rocket dockets anytime there's a child abuse case. Furthermore, the state of Utah and its criminal prosecution and DCFS have different and competing interests. For example, in this case, DCFS simply was bringing in this in the interest of the child and hold custody of the child and can create a plan for reunification. However, this would be a competing interest if the state wishes to pursue prison for the defendant's conduct. It would strip the DCFS agency of trying to reunify the party, which often is DCFS goals. This is why the Arizona court should not be followed. Because the state is a different entity, there are different issues, and the defendant has not faced prosecution for this before, this court should deny defendant's motion to dismiss and allow the state to proceed with its criminal case. Thank you.
Thanks very much. Rebuttal argument.
Just real briefly, Your Honor. The state's asserting that the parties were not the same and were not in privity. I think that argument, it really strains credibility, Your Honor, where we have the caption of the juvenile court proceeding that says plaintiff, state of Utah. is expressly the petitioner in the juvenile court action. Even if it's DCFS, they were represented by the Attorney General's office that routinely engages in criminal prosecution of the types of cases that it handles. The other argument that the state asserts what issue preclusion is not the same is because it asserts that non-accidental harm is somehow different from intentional abuse. And really it's the conduct, as the court quite rightly pointed out. It's not the outcome or the intended outcome. Non-accidental, I can't think of a closer synonym to intentional than non-accidental. Moreover, the express language of the juvenile court is in terms of abuse, the same kind of abuse at issue.
Well, non-accidental it's either the same or it's a lower standard than intentional, right?
Well, I think a lower only in terms of the outcome, right? But in terms of the conduct, in terms
I mean, if it were switched around, if there were a difference between those standards, that they weren't the same. If the requirement were showing intentional conduct, the context requirement were showing non-accidental, then the wouldn't prohibit litigation to a lower standard. It's switched around. That's like the burden of proof.
That's correct.
Failure to meet a lower standard, non-accidental, should preclude litigation of a higher standard, intentional.
I would wholeheartedly agree.
And that's similar to the clear and convincing versus beyond a reasonable doubt, right?
That's true. I think the state's last argument really is one of public policy in terms of.
But that is a reasonable argument to make. It's the argument that saved these prosecutions in some of the cases that went the other direction from the Arizona Supreme Court, right?
It is. I credit to the state for making the argument, but it doesn't really fall within the parameters of Utah law as I read it under Somerville and the problems of the issue in their issue law had a catch-all exception for public policy, and I think we have
The Michigan case, by the way.
I missed what was actually an Illinois case. 744 North 2nd 906. And
it's one of the ones that went against the application of collateral stop, right?
it did basically based on important public policy reasons, and that it said also in dicta in the last paragraph indicated that the juvenile proceeding, the state did not have a full and fair opportunity to litigate the issue of whether the defendant was criminally culpable. And in this instance, even though it wasn't a criminal proceeding, all of the elements are essentially the same, even under a lower standard that the state could not meet in that proceeding.
All right. Well, thank you very much. This is an interesting issue. I'm surprised and I guess disappointed, I'd have to say, that there's not a case from the Utah Court of Appeals or the Utah Supreme Court that speaks to this issue, because it's an issue that I would think would have come up more frequently than it has, but we don't have a binding case from the Utah appellate courts, which means that this is a purely legal issue, that I'm not making factual findings and I'm not exercising discretion here. It's a purely legal issue that I'm either going to be right or wrong about, based on whether the Utah Supreme Court would follow the authorities such as the Crosby-Garbott's case from the Arizona Supreme Court, or whether instead the Utah Supreme Court would follow cases like State versus Cleveland from the Washington Supreme Court. Or that's the Court of Appeals of Washington, actually. I'm going to focus my analysis on collateral estoppel, because I don't think that claim preclusion, res judicata encompasses collateral estoppel, which is issue preclusion, and claim preclusion. Claim preclusion is really a doctrine that's designed to ensure that parties have appropriate incentives to raise all issues that arise out of the same set of operative facts in one proceeding. And so if there's a claim that can be brought that arises out of sort of a nucleus of operative facts, then it must be asserted and it cannot be brought up later. It's a waiver of a claim that could have been asserted and wasn't asserted. That doesn't apply here because a criminal action for child abuse could not have been asserted in the DCFS proceeding up in the first district. That was only for the dependency proceeding about whether or not custody would be taken away from Ms. Barlow based on the allegation that she contaminated the PIC line with fecal matter of her infant. That was the issue in the dependency proceeding or the DCFS proceeding up in the first district. It's the same underlying factual question in the child abuse action that's been filed, but that child abuse action could not have been filed in the first district juvenile court. It didn't have jurisdiction to consider a criminal action like that. So that is not a claim. The criminal action is not a claim that could have been brought in the DCFS action. So claim preclusion does not apply. Similarly, I don't think that double jeopardy applies. She was not facing legal jeopardy, deprivation of liberty that accompanies a criminal proceeding, the action up in Cache County, the juvenile court case up there. And so double jeopardy does not seem to me to apply. But collateral estoppel may apply. And there are cases that have involved a situation like this. And just for the record, the allegation that she had non-accidentally contaminated the PIC line of her infant son, as opposed to there being other explanations for the fecal contamination of the PIC line, was litigated heavily in that action up there. It's the same issue that's at issue in the criminal action here, whether she intentionally engaged in that conduct and thereby committed child abuse, a crime of child abuse. It was not a short perfunctory proceeding. It was a 3-day trial. There were 14 witnesses who testified. 9 of them were medical doctors. The judge wrote the 36-page set of findings of fact and conclusions of law, concluding that the state had not proven by clear and convincing evidence that this was a non-accidental contamination of the PIC line by Ms. Barlow. And so it was a robust proceeding. The same issue is presented in the criminal case. Now, it's not identical. It's phrased differently in that the standard was it non-accidental contamination of the PIC line up in the Cache County juvenile court action. The question is whether it was intentional contamination of the PIC line in the child abuse action. Non-accidental is, if anything, a lower threshold. That's the state's argument that it's not an identical issue because it's a lower threshold. But similarly to the burden of proof, where inability to prove something by clear and convincing evidence, which was what the standard was in the juvenile action, would mean that you can't prove the higher standard of proof beyond a reasonable doubt. Similarly, your inability to prove non-accidental contamination to the extent that there's any daylight between the two standards means that you can't prove the higher standard of intentional contamination of the PIC line. These issues, if they were reversed, would not have preclusive effect the same way. So inability to prove something beyond a reasonable doubt, if we had the criminal action go first, wouldn't preclude litigation of whether or not the same showing can be made by clear and convincing evidence. That's kind of like the OJ situation where you get acquitted of murder. That doesn't mean there can't be a civil action, which has a lower standard. But here we have the lower standard first and then the higher standard later. And that's both with respect to the mens rea, non-accidental versus intentional, and also the burden of clear and convincing versus proof beyond reasonable doubt. So I think it is a party, there are different to the state responsibility. So the here has the responsibility for personal actions in the name of the state, and it's the Attorney General's office that has a responsibility for pursuing actions in the best interest of the child in the juvenile court setting. It is the state of Utah. It's the same party. The question is whether or not for policy reasons we treat them as different parties for purposes of the application of collateral estoppel. The state acknowledged that if this court followed the approach of the Arizona Supreme Court that this case would have to be dismissed. And so the parties have brought my attention. I don't think it's been an exhaustive 50-state survey of the approach that's been taken. Neither party has pointed me to anything that's binding from the Utah appellate courts. And you agree that there's nothing, right, Mr. Smith?
That's correct, Your Honor.
And so what I have is a case from, this was maybe one of the most recent of these cases, a 2019 case from Arizona, Nicholas Crosby Garbots versus County of Pima. It's 434 P. 3rd 143. It's from the Arizona Supreme Court. It's indistinguishable from this case. The state has acknowledged that if I follow that, if I think that's good law, if I predict that the Utah Supreme Court would follow this authority, then that would require dismissal of this case. So that's a case that goes in one direction. We have a case that goes in the other direction from Illinois, People versus Moreno. The citation is 744 Northeast 2nd 906. We have a case that goes in the direction of issue preclusion, state Bowling versus State from the Court of Appeals of Maryland, 298 Maryland 396 or 470 A 2nd 797. The court there held that collateral estoppel did apply in circumstances like this. We have cases from the Court of Appeals of California that go in both directions. There is a Lockwood versus Superior Court case that finds, and it's a California Court of Appeals case, 206 California Reporter 785, that finds that collateral estoppel does apply. There's a later case also from the Court of Appeals of California, a different division of the Court of Appeals of California, People versus Percival. The citation is 12 Cal Reporter 2nd 331 that finds that collateral estoppel does not apply in circumstances like this. And so they're really kind of evenly split. Formally, the elements of collateral estoppel are satisfied here. Even the courts that went in the other direction that I just mentioned, for the most part, found that the elements of collateral estoppel were formally satisfied here. They based their determination not to apply collateral estoppel essentially on policy reasons. And those included a discussion of different entities from the state that had different responsibilities. Essentially, the argument that Mr. Cervantes made that, it may be the state, but it's different aspects of the state with different responsibilities. So that was an argument that was made. There was also an argument made in some of the cases that the proceedings that involved child endangerment, essentially the analogs to the DCFS proceedings that occurred in Cache County for purposes of this motion, were more truncated proceedings, that they were not as robust as the trial proceedings that would occur in the context of the criminal justice system. In this case, it is the state of Utah in both of these cases. They have different responsibilities, but it's a large entity. And ordinarily, I think when we have a large entity that has different divisions and different responsibilities, the mere fact that there are different divisions and different responsibilities doesn't stop us from applying collateral estoppel. That's true of large corporations with different responsibilities. It's the identity of parties. And so the Arizona Court of Appeals found that. Also, we don't have a situation where, at least in this case, there was some sort of truncated, abbreviated proceeding in the juvenile juvenile court matter. It was a 3-day trial. It probably was as long or longer than, maybe not longer, but maybe as long as the criminal trial would be in this case. It involved testimony of 9 medical experts, 5 lay witnesses, that resulted in a 36-page set of findings and conclusions by the judge up there. So it was not a matter to which he gave short shrift. In predicting what the Utah Supreme Court might do, there is an analog that's been endorsed by the legislature of a criminal proceeding being barred by a single fact finder, a judge's determination of whether or not the state can prove an essential element of a claim prior to trial. And that's the justification hearings that we have now, where the state is, the legislature has decided that if we have essentially a trial on the essential element of non-application of self-defense, and the court finds that the state hasn't proven by clear and convincing evidence that self-defense doesn't apply, that bars subsequent criminal prosecution that involves all of the other offenses. And so this notion of a judge looking at something with a lower standard of clear and convincing evidence precluding a later criminal prosecution is something that's not foreign to Utah law, at least now. And so I say these things not because I think that's dispositive of the issue, but I have to predict what I think the Utah Supreme Court would do. And I think on balance, it's likely that the Utah Supreme Court would follow the lead of the Arizona court and would apply collateral estoppel in circumstances like this. I may be wrong. I could be wrong and so I'm going to grant the motion to dismiss for those reasons. If I denied the motion, I could be wrong. I'm either right or wrong depending on what the Utah Supreme Court decides the law ought to be in Utah. And so the motion is granted based on the court's application of collateral estoppel, not res judicata or claim preclusion, not double jeopardy. I think that the rule that I'm going to use to dismiss the case is Rule 25A, where the court, this isn't discretion, it's mandatory dismissal. I mean, I guess it is 25B2 fits best in the sense that when collateral estoppel applies to an essential element of the offense, then there is not a public offense stated in the information. It'd be nice if one of the subsections of 25B were more specifically tailored to this. But in any event, it's the court's intent to issue a dismissal that would fall within the meaning of Utah Code Annotated Section 77-18A. -13A, which provides that the prosecution may, as a matter of right, appeal from a final judgment of dismissal, including a final judgment of dismissal. So this is a final judgment of dismissal, regardless of whether I identified the correct subsection of Rule 25. The court intends this to be a final judgment of dismissal within the meaning of Utah Code Annotated Section 77-18-1. Sub 3, sub A. And so this is something that the state can appeal. If I were to rule the other way, it would have to be an interlocutory appeal, but I'm persuaded by the authorities that go in the direction of granting the motion. And so that's my reasoning and analysis. Any questions from counsel?
No, thank you, Your Honor.
No question, Judge. I think this is an issue that should be fully litigated. I hope Your Honor doesn't take offense to an appeal if one is.
No, I encourage an appeal. I think everyone would benefit from us having a clear answer in Utah to this question because the authorities go in other directions.
Right.
In opposite directions from the other states. And I think we all would benefit from having a clear answer in Utah. So I encourage an appeal. I would encourage an appeal from you, an interlocutory appeal if the outcome had been different. And so there will be no offense. In fact, I'll be disappointed if you don't appeal.
Okay. Thank you, Your Honor.
Okay. Thanks very much. The case is dismissed.
Thank you.
Judge, could we address the Mario Serrano matter, please?
State of Utah versus Mario Serrano, case number 251-902-994.